All right, Attorney Alfred and Mr. Adams, do you have an announcement on your case?
Yes, Judge. It looks like we haven't come up with any type of agreement or settlement in this one. From my notes, because these are three different cases, like it is defendant's belief that this case has been consolidated. I didn't have it in my notes. But the way that he's explaining it and the way that I see the way these cases are showing in my notes, it makes sense that maybe it might have been consolidated. However, there's a garnishment for one of the cases, and then the other two, we would need a trial for. But
So there's a
defendant is claiming,
consent judgment on, so position number 12, it's case 24M03831. There is already a consent judgment in that case. And we're here today on the defendant's motion to vacate the default judgment. So let me let me pull that case real quick. So that's position 3 on my calendar. I think we can maybe dispose of this one quickly and then decide what we're going to do on the others. So
okay.
there is a consent judgment. It's a little bit confusing, but it was signed by Judge Grant on December 9th of 2024. And it looks like there was an appearance by the plaintiff, an appearance by the defendant, and it was a consent judgment, and it was a judgment entered in favor of the plaintiff against defendant Gabriel Adams in the amount of $3,764.75, plus attorney's fees in the amount of $54. So I'm not going to vacate a consent judgment. Okay. Okay, if that was agreed to by the parties at the time, I don't have a basis to vacate it. It was, it was a consent. So go ahead, Mr. Adams.
That in the system says consent judgment, but that is not accurate. It is not a consent judgment because I did not consent on any judgment at that time because this is fraud. All of this is fraud. So that being a consent judgment is not accurate in the system.
So it says the notes in the case said that from October 16th of 2024, Attorney Feingold and defendant appeared and confirmed that the case was previously heard and ruled in plaintiff's favor by Judge Grant. A proposed order was to be submitted to the court. It must have gotten lost. Attorney Feingold is going to resubmit the proposed order directly to Ms. Smith, who will forward to Judge Grant. So whether it was a consent or it was a trial, it sounds like Judge Grant ruled on it, and there was a judgment entered against you in the favor of the plaintiff. Okay, so it was not a default judgment. So there's nothing to vacate. I can't vacate a trial. I mean, the way to challenge that is by a petition for review within 30 days from the date that the judgment was entered. So I'm not going to do anything with that. Okay, I'm not gonna upset that apple cart. So I'm going to deny your motion to vacate on that case.
Your Honor?
Yes.
I want to bring forth this because since that time from that motion to vacate, addressing that consolidated judgment, since that time, the plaintiff attempted to enforce that garnishment, but Gwinnett County dismissed it, as well as the plaintiff decided to voluntarily withdraw themselves from that.
The garnishment.
That's correct.
Okay, and so that case happened probably in Gwinnett because the employer or the bank was registered in Gwinnett. Okay, so I have nothing to do with that garnishment. Whether the plaintiff chooses to collect on their judgment or not is not something that has any relevance to the underlying case, which is what we're here to discuss. In that case, you had a motion to vacate default judgment. I'm denying that. Whether the plaintiff wants to choose to collect on it or not in the future, I don't know. That has nothing to do with me. Okay. But it was either a consent or it was a trial order. I can't tell, but it was definitely a judgment. So, and that was, over a year and a half ago. So I'm not gonna dismiss that judgment,
Yes, ma'am.
okay?
Yes, Your Honor.
So as to the other two cases, position number, 1 and 2 on that calendar. So it looks like you filed an answer. I'm looking at position, well, the one that ends in 2763. Request for validation of debt. You filed an answer. The answer was timely. You filed a motion to dismiss, and a request for sanctions, insufficient service of process. It looks like you were served personally on October 22nd of 2023 by a private process server. And you've raised some like attempts to be counterclaims, it looks like, for FDCPA violations and other things. Do you have a lot of documents that you want to show? Do you have any evidence or anything like that you want to introduce?
Yes, ma'am. All of that should be in the court system. I have a FTC report. I have a fraud verification report. I have police report. I also have medical reports as well in those documents. So everything supports the fraud claim with all documents inside of it. So the court should have those files.
Okay. All right. Ms. Alford, do you have anything you want to say?
Judge,
How
just more so. Oh, sorry.
No,
Can you hear me?
go ahead. Go ahead. Sorry.
Okay. Just more so that we don't have the documents of well, I don't have the documents of defendant's fraud report. However, with these cases, my client did do a fraud investigation, and did not find any fraud. Also, mailed defendant a validation of debt upon his request. And so, for one of the cases, we also have a 902 affidavit against defendant. The thing is, if it is fraud and he does have those documentations, I just want to be thorough here in making sure that I was going to ask for a continuance and making sure that we don't have a judgment against him if in fact, at least like one of these cases are fraud. I just wanted to figure that out and be thorough about it.
Okay.
And be fair.
So, Mr. Adams, it sounds like Ms. Alford is asking for a little bit more time to sort out this case and investigate into it. I'm inclined to go ahead and grant her request for continuance and set this for an in-person trial. I think it'll just be easier for everyone. How do you feel about that?
Your Honor, thank you. I don't 100% agree to it because this has been a whole big situation for a long time, and I suffer with issues with PTSD. Throughout this entire situation, I don't even think any of this should be happening because it's not my fault. And so I have a Justice Department report to prove such things of the fraud. I also have the university report to prove such thing, which is fraud. I have a Social Security affidavit to prove it was fraud. And I also have other things. Also, you said something about receiving, that it was personally received by me. That was also a violation, which we put in the document, notifying that a yard worker was given that documentation, not me. So that in itself was a violation, but everything should already be in file with.
And have you sent all of those documents to the plaintiff?
Everything. Yes, ma'am.
Not to me, to the plaintiff.
I have sent everything to Attorney Feingold, and there have been many attorneys that's already been working on these cases.
Yeah.
And that's why the judge originally consolidated it all, because she felt like it was too much. And so she just made it as one. And Attorney Feingold was the original one that was working with it, and he understood, and he is the one who actually sent the dismissal for the garnishment in the first place. So I'm not understanding why there would be a continual. Judge, it's up to, of course, Your Honor, is whatever you say, but at this point, I think that I have exhausted a lot of things, and I've proven all my evidence and everything in the system. I don't know why I'm still having to fight such case when first it's not mine.
Well, we need to have a trial. We have not had a trial yet in your case, okay? So, I have a lot of other cases to deal with today, and I have a 1 o'clock calendar. And I know it's not even, is it 10 o'clock yet? It's just around 10 o'clock. So I'm happy to put you down for a trial and see, Ms. Alford, you really haven't received the documents?
No,
From him?
I don't, we don't have any in the records. I'm looking in his records right now. We don't have any documents. I can look again. But
Okay,
I would
so
like
why don't
to,
you chat him your email address and he can
and
email you?
I did, and he told me that he would send it as soon as he got his hands on it, which
When was
didn't
that?
really like clarify.
Was that this morning?
Yeah, this
Yes,
morning
ma'am.
when we spoke in the breakout room.
All right, Mr. Adams, are you able to email her your documents, your evidence now? Because she's got to have eyeballs on it.
I
She
will only
can't
be
help
able to take,
you.
I'm sorry.
Go ahead. You're
I'll
fine.
only be able to take pictures. That's why I said I need to get to a scanner or a fax so that I can send it, even though I already sent it to them already. Attorney Feingold should have all that information. I don't understand why the attorney firm does not have that. And there's so many people that's been working on that's where the frustration is, Your Honor, that there's been so many attorneys working on these cases and there is no clarity amongst them. But I've been telling the exact same thing over and over and over and over again. And so I provided evidence to both the plaintiff and the court to support such claims. And now she's saying, or they saying they don't have it.
Well, maybe I can help with this transfer of documents. Ms. Hathorn, could you please email Ms. Alford all the documents that are related to I think it was an exhibit that was filed in on February 26th. Go ahead and send those to Ms. Alford. I'm going to put you guys on the list for the trial. I cannot promise that I'll be able to get to it today. Okay. So that's just the way my schedule works. Okay. All right.
Thank
so
you, Judge. And I see that defendant, Mr. Prophet also is online. So I don't know if there's a breakout room for him, but I'll join that as well.
I don't know what that is. That is a different case.
Yeah, it's a different case. It's position number 1 for garnishments.
Oh, but yes. Okay. Oh, was he
Yep.
originally a no response? Okay, but he's here now. All right. So
Yeah,
Mr. Prophet, I'm going to go ahead and place you guys in a breakout room so you have an opportunity to meet with Attorney Alfred on your garnishment case. Okay.
Thank you.
Thank you.
And Your Honor, before Attorney Alfred leaves, update, there you go, thank you. She chatted me.
Okay, great. Thank you. All right, Miss Alford and Mr. Adams, you can come on in. Wait 1 second, let me just. Okay, so, did y'all have a chance to speak after I addressed the two of you?
No, ma'am.
No, you did not talk again. Okay,
No.
and Mr. Adams, you had your hand up while I was dealing with another case. Is there something you wanted to tell me from that?
I just wanted to see what my next move, what you wanted me to do from there. So I just
Okay.
sat patiently.
Okay, thank you. That was exactly what I wanted you to do.
Yes,
So I
ma'am.
appreciate that. How many exhibits do you have to present today, Miss Alford?
I have about 3 exhibits to present today. I'm just looking through. We filed a 902 affidavit with the court. I have the envelope number for that.
Can you just remind me what that is?
Yeah, the envelope number is 21072225.
And is that, you filed that in, you filed it into the case when?
Yesterday, Judge.
And that's the certified business records?
Yes, Judge.
And then Mr. Adams, how many exhibits do you have?
I believe 6. 1, 2, 3, 4.
All right, Miss Alford, did you receive them from Miss Hathorn?
7.
I did, Judge, and I'm trying to quickly review them. I was working with the other defendant at the time, so I'm just trying to quickly look over it right now. Sorry.
So Mr. Adams, you have the incident report, is that right?
That is correct. I have an incident report. I have, I'm sorry, go ahead. Yes,
Well,
ma'am.
yeah, so let me go through them in the order that I see them. So I
Okay.
see an incident report, I see a letter from the DOJ.
Mhm.
Right, I see a letter from Mercer.
Mhm.
I see something from the Social Security Administration. Dated October 14th of 2022. Okay. I see a cease and desist letter. I don't know who that was to, when it was sent. I don't know what that is. Is that an exhibit that you intend to introduce?
This was an exhibit that we produced, this is our 5th hearing for these cases. So we have presented a lot of information to support my claim.
Okay, so are you intending to introduce this cease and desist letter?
Yes, ma'am.
Okay. What is this log, this phone log?
Those are, that connect to the cease and desist.
Okay. Okay. Mm. A Grady Hospital bill or
That-
discharge statement?
Yes, ma'am. That is to support the claim of me being incapacitated during the alleged account creation. You should have pictures to support that. That is attached to that as well.
And then an identity theft report.
That's correct.
So that's 1, 2, 3, 4, 5, 6, 7 documents. Is that right?
That's correct.
Ms. Alford, you have all 7 of those documents now?
Correct, Judge. I'm looking through those.
Okay, and Ms. Hathorn, the envelope number that she gave you, that's the affidavit, has that been uploaded yet? I'm sorry, I can't. hear.
Yes, Your Honor.
Okay, to position 1 or 2, or both?
That is uploaded to, give me one moment to verify this.
I see it now. It's on position 2. Is this relevant,
Okay.
this affidavit for both cases, Ms. Alford?
Yes, Judge.
Did you submit it into the first case as well, into case 12763?
I believe I submitted it into case. Let's see. There was only a 902 for one of those cases, Judge.
Why?
Let's see. I'm just looking through my notes. Yeah, we requested a 902 from client on the other case, but was not able to get some information from client within the time frame. So it was more of a timing thing, unfortunately.
Right. So it sounds like on position 1, you're not going to be able to prove up your case then. Is that right?
Yes, Judge, and the thing is, and that's why I was trying to speak about it before, is if defendant is alleging fraud on that one, and I'm looking at the documents for that one, or for the exhibits that he sent, then I would respectfully again request a continuance just to look into the fraudulent investigation for that one specifically. If that's okay.
Well, he's saying that he already sent them to you. Mr. Adams, when did you send the plaintiff the exhibits on case 23M12763.
In 2024?
Judge, is there service?
Minute. I believe it was 2024. Let me go back to the.
So the motion to dismiss and request for sanctions. I don't see a certificate of service, but that's not unusual in a pro se case.
But we didn't have any documents from him for that specific case. And so now that I do have these documents, I would like to report this up so that we can take a look at it again.
Did you do a fraud investigation on the first case, 2763?
I think I'm getting confused with the case numbers. We did a fraud investigation on 23M1488.
14881?
Yes.
Okay. But you did not do one on 23M12763.
No, it does not look like it. It looks like he requested a validation of debt and we provided that. But from my records, like I'm looking at it and I can look at it again, it doesn't look like we did a fraud investigation on that one.
So in his answer, let me just make sure. And there's a motion to, so we're talking about 12763 now. He filed a motion on July 16th, 2024. It was a defendant's motion to dismiss and request for sanctions in both cases, actually all three cases. Did you receive that motion? Do you have record of that motion?
The motion to dismiss, let me look at it right now, to see that we have it. Sorry, I have like a few things up on my screen, so.
I mean, in that motion, the first thing he raises is identity theft. So I think you did have notice of that issue from at least July of 2024.
Right, and I'm looking through my records from May of or from March of 2024. And I don't see it here
Well,
in like our
That would have been
documents or
before
records.
he filed it. March of 2024 is before he filed this motion in July of 2024.
Right, I'm saying I'm looking at everything from March up until
Oh, okay.
2026.
Okay.
And, you know, I don't see that. I did see his answer for the other case, right? Unless it all got mingled into like those two got mingled into one case together. But in terms of like separate cases, I don't see it for this case, for this specific case.
Okay. So you never received the motion to dismiss and request for sanctions in 12763.
No, yeah,
Okay.
no.
Okay. So that case, then I am going to continue. We're going to reset it for trial. I'm going to set this for an in-person trial. Mr. Adams, are you here in Atlanta area?
Yes, ma'am, I am.
And I know you've had some health issues. Are you able to be in person? I think it will be easier in person.
It's a struggle, but I can do whatever you require for me to do, Judge.
Okay. I'm going to I'm gonna reserve the right to change it after we have a hearing on position number 2 and see how it goes. If it's very difficult, then I think it will just be easier in person, but, because I think that they did not have notice. Arguably, they did not have notice of your motion to dismiss and the identity theft issue on case number 1. Because in your mind, all of these cases, they're all the same transactions, they're all the same issue, you're dealing with them. Law firms handle things differently. Every case gets kind of in its own silo. And so if the thing doesn't specifically get filed or sent in each specific case, it really needs to. And so I'm not saying that you shouldn't have an opportunity to raise those defenses, but I am saying that they should have enough time to prepare how to respond to those claims, okay? So, but on position number 2 on my calendar, which is 14881, they did receive the motion to dismiss. They did do the fraud investigation on that case. So we are going to go forward on a hearing on that case now. Okay. All right. So, so we're going to reset position number 1, and it's going to be April 9th at 9 a.m. in 1200 C. Does that work for you, Miss Alford?
Yes, Judge, that works. You said April 9th at
Yes.
9 a.m.
Yes, exactly. Okay, and Mr. Alford, or excuse me, Mr. Adams, is there any reason why 9 a.m. doesn't work for you? Sometimes people are not good in mornings or not good in afternoons.
9 a.m. would work, but could I say something to it? Is it okay?
Yeah, of course.
I'm an objection. I respectfully reject the continuance because this is today would be the 5th hearing on this. And I think that the plaintiff had plenty of time to produce documentation proving that I opened these accounts and authorized this stuff. And each time it has been the same exact thing. Oh, I don't have this information. Oh, I'm sorry. Oh, let me look. Oh, so it's a continual thing with different attorneys.
If there was a certificate of service in here that was your signature saying, I sent the motion to dismiss to them in this case on such and such date, I would not be continuing it. But because that's not there and they're saying they don't have it attached to that case, I'm giving them, I'm going to go ahead and grant the continuance in that case. Okay. And I understand that you're, frustrated and this has been going on a long time. I also feel like this is the 5th hearing on this case. I don't know why. It's really hard for me to see what happened in this case. And so it's not that I see that there were hearings, I mean, starting back in January of 2024. But it's not always clear to me. I just can't exactly why they were reset. So anyway, that is my decision. I'm going to grant the continuance on position number 1. On position number 2, I would like to proceed with the trial now. Okay. Do you have something you want to say?
Me?
Yep.
I think the confusion is because I believe it's Judge Williams. She put the cases together, and I think that's the confusion.
I don't see an order to that effect. I hear you saying that, but unless I see an order consolidating all the cases into one, I just don't see it. And so they are 2 different credit cards. They're 2 different account numbers. They certainly could be consolidated, but I'm not going to do that. Okay, so that is going to be my first ruling. I'm going to not consolidate.
Yes, ma'am.
Okay. All right, so for the information of both parties, the plaintiff has the burden to prove to the court by a preponderance of the evidence that they are entitled to what they are asking for today. If the defendant has raised any counterclaim, the defendant has the burden to prove to a court by a preponderance of the evidence that they are entitled to what they asked for in their counterclaims. When I call a case for trial, I will give both parties an opportunity to present their claims and defenses. We will start with a very short opening statement where you can tell me, actually, we've kind of already done opening statements. I sort of know what what your defenses are, identity theft, et cetera. The plaintiff is the party that filed this case, so they're going to go first. After opening statements, the plaintiff will call their first witness. I believe that they do not have a witness. They're going to rely on their certified business records. Is that correct, Ms. Alford?
Yes, Judge, that's correct.
Okay, so you'll look at the records, and then once they've rested their case, you will have the opportunity to, testify or call any witnesses that you have. And the plaintiff will have an opportunity to cross-examine you as to any of the documents that you introduce or any of your testimony. I may also ask questions of the witness just to keep things, of either witness, just to keep things moving. After both parties have had a chance to present all their witnesses and evidence, both parties will have a chance to give me a short summary of the evidence that was presented if they so choose. Neither party may interrupt the other. I expect that each witness will be allowed to testify without interruption unless there's a legal objection to the testimony. I promise that both sides will get their chance to make their case, and I thank you in advance for your patience while allowing the other party their turn. And Mr. Adams, do you have a witness other than yourself?
Not right, no, ma'am.
No, okay. So I may make a decision from the bench today, or I may take the case under advisement and issue a ruling later if I want to do research or consider your arguments and evidence further. Please make sure that my clerk has your email addresses in our system so that you will receive the court's ruling by email. All right, and Mr. Adams, I did swear you in already, correct?
No, ma'am.
Okay, raise your right hand for me then. Do you solemnly swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes, ma'am.
Okay, thank you. All right, so I'm going to let Ms. Alford go first since this is her case.
Thank you, Judge. Judge, we're here today seeking a judgment against the defendant for the deficiency balance remaining on the credit card in the amount of $5,978.53, plus the court costs. The defendant opened an account with Capital One on March 30th of 2022, and the last payment or charge-off date for that credit card account is February 18th of 2023. And so we're prepared to speak about or explain the 902 affidavit. We filed it with the court, and those all have all of the records for this case and for this account. And so at this time, Judge, we're just asking that the court enter the judgment in the amount of $5,978.53 plus the court costs.
All right, so Ms. Hathorn, how do you want to do exhibits? Do you want to do them?
Your Honor, it would be up to you. The plaintiff's attorney, well, the attorneys usually share their own.
Okay.
In the documents that were sent to us, I would usually post.
Okay. All right. So Ms. Alford, why don't you walk us through your business records and the affidavit so Mr. Adams and I can see them?
Okay, no problem. I'm just gonna pull it up on here and then share my screen.
Yes, that would be wonderful. Thank you.
Sorry, I couldn't see where I can unmute myself at. All right. Is everyone able to see my screen?
Yes.
Right. So this first page of the document is the certificate of service. Let me go to the next page.
And just because I don't know the answer, what is the rule on how far in advance this certificate of service and the 902 affidavit has to be served on the opposing party?
Sure, Judge. So typically, we did, well, however, while we did file it yesterday, I would just like to make the argument that defendant has a chance to look at it. I was trying to send this over to defendant as well. I mean, we also mailed it to him, but I would also try to send this over to him so that he could look at it. And that was my reason for continuances, just so that everybody could have proper notice of this document here.
Right. Mr. Adams, have you seen this document before?
No, ma'am, I have not.
And Are you waiving the right to review this document in advance of the trial?
Yes, ma'am.
Okay. All right, continue.
This next page again is just explaining what the letter would entail, or what the business records would entail, or explaining that this is the business records from Capital One. And here we have Shamaya Grenny.
Can you make it a little bigger, please?
Sure, I'll try. Let's see. One second.
That's better.
Is
Thank
that
you.
better?
Yep,
Okay.
much better.
Alrighty. And this is the affidavit. Shamaya Grenzy explained that she's authorized to sign off on these records because it's just personal knowledge of them. She works for Capital One, and she's aware of defendant's account.
Okay.
It'll also explain that the amount that's due, as well as when the charge off, which I explained in my opening statement, was, as well as the last digits of the account number. And that was signed and notarized on March 3rd of 2026. Here, this is like our, I guess, first exhibit. And this dates June 14th of 2022. So, well, actually April 20th of 2022 through May 20th of 2022. These show what was owed in the statements for that time.
What was the balance on that date?
The balance on that date was $2,992.87.
Okay.
This also shows just like the breakdown for that month that I just spoke about of what was paid. So there's just different grocery stores, Chevrons, things like that, to show that there were some transactions made on the account. The next exhibit, the balance is $4,821.21. And this is from May 21st of 2022 to June 19th of 2022. This also shows that defendant made some payments as well as some transactions. And it explains that the previous balance was there and got tacked on from the new transactions. And it has the same card number ending 4726, as well as defendant's name and address. And this shows the breakdown of the payments and the transactions that were made.
Give me one
For that
second. I'll
month.
look at something really quickly.
Oh, sorry.
Okay, go ahead.
Next we have from June 20th, 2022 to July 20th of 2022. Again, same card number, same name, same address. Payments were made of $169, as well as some transactions of $524.20. And that balance for that time was $4,704.41. Again, that is the breakdown of the payments that were made, as well as the transactions that were made for that period. And then here, we have the period of July 21st of 2022 to August 20th of 2022. Same name, same credit card number. And then the new balance was $5,149.85. This also shows the payments being made as well as the transactions for that month. And then again, the breakdown for that month.
Okay.
And this goes on, so August
Yeah, why don't
21st
you
of
skip to the
2022.
the last one that you're basing the
Sure.
balance on before the charge off?
Yep. Sorry, I can't move the. Okay, so this was, the charge off was on February 18th of 2023. This right here shows that amount that's due. And if you look at the amount previous to that, right, you have the 5,850 and 46 cents. Oh, wait. Yeah, January. And it has like the payments that were made and transactions. And so then that amount is tacked on to here. There was a $40 payment made, as well as some transactions, which totaled the balance to $5,978.53. Whereas, yeah, that's the amount that we're asking for.
Is that all?
Yep, that's it.
Okay, you can stop sharing your screen. Thank you. Mr. Adams,
Okay.
do you have any questions for Ms. Alfred?
Yes, I do have a few questions. The first thing is you said that this is a report that you received from Capital One, but did you see a wet signature on those documentation?
Oh, wait, your screen is showing something else. I don't know what it is. Give her 1 second.
Sorry, I'm trying to stop the share screen. 1 second. Let's see. All right, there we are.
So the question was, do you have a wet ink signature contract?
From Defendant?
Yeah.
I have the original terms and agreements of the contract and the terms and conditions.
So no.
Typically with a credit card agreement, there's not necessarily, especially with Capital One, there's not necessarily, may not be a wet signature, but if the terms and agreements were sent to you, the contract is made, and it explains that it's made once payments are made with that credit card. Right, so you agree to that once the payments are made with the credit card.
When you say payments made, do you mean charges? Using the
Charges, yeah.
card,
So,
or
like,
you mean
once-
making the
once
defendant
using-
making a payment?
No, using a card in general.
Okay. Got it. Any other questions?
So there's no document showing that I personally opened this account, correct?
The documents showing that you personally opened the account. I mean, I even showed that you also used the account, same address, same name, same credit card number. And like I said, the contract basically states that once the credit card is used, right, you agreed to pay the money back. You agreed to be in contract with Capital One.
Do you have any identification document to show that I applied for that account?
I can look through our claim images and provide that, but based on the law and like what I'm supposed to or required to present, not required to present that. I believe that with the business 902 affidavit and the testimony from the person that is over the Capital One accounts, what they provided me is more than enough evidence to show that there was payments, there was an agreement, and that, you used their credit card.
Your Honor, can I respond?
This is not your time to testify. You'll have an opportunity to raise any arguments in your own defense. This is still cross-examination. So if you have a question about the process, yes, otherwise I don't want to hear testimony from.
No testimony, just question. So
You
the
can ask your questions.
So the 902 affidavit doesn't admit that the person did it. It just shows documentation on their side that it was created.
No,
Right,
it shows, oh, sorry.
Are you asking me that, or are you asking her that?
Whoever answers the question, I'm not certain who to ask that question to.
So,
Your
I mean,
Honor.
really, it's a question for your own lawyer. So I can't, the 902 affidavit is a certified business record. So what that says is they can introduce documents into evidence without having a live witness present. Now, you have the right to cross-examine her on those exhibits, understanding that she doesn't have any personal knowledge of them or raise any defenses about those exhibits. But it just allows me to look at the documents, even though they would be hearsay otherwise.
So I'm gonna repeat basically what I receive. That's okay?
What you
From what-
received, what I just said?
Yeah, yes, ma'am. Can I,
Yeah.
so I know that I'm saying it right.
Sure, sure.
So it allows you to record and admit the live custodian, but it does not establish that I entered into the alleged credit agreement or whatnot?
It's just allowing me to look at the documents.
Okay,
Okay, she
Okay.
still has to argue and prove her case.
yes,
You know,
ma'am.
she could have a certified business record for a piece of toilet paper. It's as good as, you know, what it is, right? We used to say in law school, you know, like an orange peel or whatever. You know, so I look at the documents for what they are and assume that they are accurate records. Do
Right.
they prove her case? That's for her to argue and for you to deny.
Yes, ma'am.
Does that make sense?
Yes, ma'am, it does.
Okay, all right, go ahead.
My next question is to the attorney. Have you met me before?
We've met just today, over the hearing, but no, not prior to this.
Were you present when the account was open?
No, I wasn't present when the account was open, but I don't necessarily have to be present for when the account is open. I am representing Capital One, who is the one that is pursuing action against you for this amount.
Okay. Did you personally witness me apply for the account?
No, I did not.
So today's testimony is based on reviewing company records, correct?
Correct, business records.
Do you have any signed credit agreement bearing my signature?
Like I said, at this time, you know, this 902 affidavit shows what they have in the business records of what was agreed upon, as well as what was used based off credit card information and your name being on that credit card. Those are transactions, it spells it out. And so, yeah.
So there is no signed contract showing that I personally opened the account, correct?
I'm not saying that there's no signed contract. What I'm saying is what I have today in front of me are the business records affidavits that shows that you've used this credit card, meaning that this credit card was opened up by you, had a name on it. Additionally, I would like to add that with Capital One, they also send bill, right, or to clients or their consumers, stating that, you know, this transaction was made. And so you should have gotten record of it, right? Every month, like every periodic month, the way that it's being shown. And so if you had any objection to that, like, oh, hey, wait, that's not mine, you know, that could have been brought up previously too. That's all I'm saying.
To that, do you have any photo identification connected to the application?
Photo identification?
Yes.
Are you
Do you
asking
have
me connected to the
any type
application?
of
I
any
didn't
type
present, okay, so I can only speak on the business or record affidavit that I presented in court today with the 902 affidavit, right? Like I can only speak on those transactions. Cannot speak on your photo identification of the application because that's not what I presented today in court.
So as we sit here today, you cannot provide proof that I personally opened that account, correct?
If you would like for me to provide proof, I think that the 902 affidavit gives proof enough. But if you would like additional proof, in which I tried to discuss with you prior to this trial, is that, you know, we also sent you a validation of debt, which, you know, I can present to judge, but that was presented to you back in February of this year, 2026. We gave you a validation of debt upon looking into your fraudulent claim. And so that also further proves or shows that this account was in your name. It was used, right? And so therefore money is owed.
Okay, so let me just stop both of you for a second. Both of you are trying to convince me, okay? You don't need to convince each other of your argument. So please just answer the questions. We can take the temperature down just a little bit. I think the questions that you're asking, Mr. Adams, are valid questions. Ms. Alford, if the answer is no, the answer is no. It's up to me to decide whether or not there's enough proof for you to make your claim, okay? All right, keep going.
I think the attorney was finishing her statement.
I think she was done.
No, I was.
Okay.
She said that
okay.
she had offered to send you additional proof. She sent you a validation of debt in February, I think, of 2026, and upon looking into the validation of debt.
Okay.
You have any other questions for her?
I don't have any other questions. That was my final question.
All right. So, do you have any rebuttal, Ms. Halford? Anything else you want to offer or say?
No, Judge, at this time I don't.
Okay. All right. So we're going to turn to you now, Mr. Adams, and this is going to be your turn. I will, and I think it's going to be easier if we just all look at the documents independently since we all have them. Let me make sure I'm looking at them too. So I'm looking at these documents that were submitted into the court on February 26th. And the documents that we went over already. So that's what we're gonna be discussing. Mr. Adams, we're not gonna be able to look at anything else at this point. Since nothing else has been submitted to Miss Alfred, okay?
Yes, ma'am.
But I think that's what you want me to see, right?
Correct.
Okay, so why don't you go ahead and tell me your story or tell me what you want me to know, and as you want me to look at the document, just tell me which document you want me to look at. We'll look at it together.
Yes, ma'am.
Okay, and I think Ms. Hathorn, I am gonna ask you to do the share screen because I'm afraid of showing something that I don't want to have on public. All right, go ahead, Mr. Adams.
Hello, Your Honor. Good morning back to you again. The plaintiff alleges that I owe a debt for these cards, and I dispute liability because my personal identification documents were stolen and my identity was compromised. For the first exhibit, we have the police document. For those who can see it I have it in paper. It alleges and shows that my automobile was broken into, my wallet was stolen, a lot of things were taken out of the car. So
Okay, so let me just ask you a question. This was filed when?
this was
March 20
filed March 15, 2020. So from
Ms.
that,
Alford, do you have any objections to me looking at that?
Judge, no, Judge, I don't have any objections to you looking at the police.
Okay. All right. Okay. All right, keep going, Mr. Adams. Sorry I interrupted you.
yes, ma'am. I have presented the evidence that my identification was stolen, and that includes my social security because that was also incorporated within the wallet. I have the social security.
Okay, so wait. Okay, so you just made reference to a document. Is it something you want me to look at?
Well, it's already included within the exhibit. So this is the police. I just showed the police incident. Now I have the Social Security Administration to prove that I went into the Social Security office on October 14, 2022 to rectify this situation.
Okay, so this letter, October 14, 2022, it's a receipt that you applied for a social security card. Is that correct?
That is correct. That is for a new one.
Okay, okay. Miss Alford, do you have any objection to us looking at this?
No, Judge, I just to clarify, you said the police report was filed when, in what year? Mr. Adams?
I'm sorry. That was
When
March
was the
15,
police report filed?
2022. I mean, 2020.
March 15, 2020. And then you filed for a new Social Security on October 14, 2022?
That's the second attempt that I tried to file for, and I never received anything. This is the only documentation that I had to support such claim for me going to the Social Security office. They were not
Okay,
very
so
helpful
the-
the first time, so the second time when I,
Miss Alford, we're not doing cross-acts now. Hold it,
Okay,
please.
no problem.
Okay, so just, do you have any objections to me looking at this letter from October 14th
No,
of 2022?
no,
Okay,
from the moment that they stole my identification, it took me about a couple of months to figure that they actually received it, because I'm not one to hold my cards or anything along with me like that. And so from them stealing it, I had to take proactive and counsel and close every account that I had. Along with that, in 2021, we suffered a major explosive experience where I almost could be dead, where I was part of an explosion where it burnt my face, my hand, and my leg, which caused me to be incapacitated for a long period of time. And so creating accounts was not something that I was doing, because my mental capacity was not even able to hone on to those opportunities to do that. And you will find such thing. Here's just a picture of what I look like. It's because the Lord has been good. I don't look like what I've been through. And this is all my hand as well. And you can see it in person. I'm still dealing with neuropathy, as you can see from my hand right now, which goes along with the Grady affidavit to prove on 01/11/2021 that I suffered these situations. So it was kind of difficult for me to get back on my feet, because I'm dealing with neuropathy as well as mental issues from that explosion. So I was not really doing anything at all for the amount of 3 or 4 years.
okay, so hold on for 1 second.
Yes,
So,
ma'am.
Miss Alford, do you have any objections to me looking at the photos that he introduced?
no, Judge, no, Judge.
Do you have any objections to me looking at the, I don't know if it's a discharge note from Grady?
No, Judge, no, Judge.
Okay, thank you. All right, keep going, Mr. Adams.
While we were going through the recovery process for over 3 years, there have been multiple breaches in my accounts. My mail was stolen, my data was stolen, all of that. And you see, if I can find it, exhibit from Mercer University. Mercer University confirms that there was a data breach to receiving all of my information. I had that in my hand just a moment ago. I cannot find, but here it goes. Here it goes.
So before I look at that, Miss Alford, do you have any objections to me looking at this document?
I didn't have a chance to look at this document here.
Take a
I'm just
minute.
trying to scroll to look. Okay, thank you.
Thanks, Miss Hathorn.
Okay, no objections to this, Your Honor.
Okay, thank you. All right, keep going, Mr. Adams.
In addition, we have a U.S. Department of Justice document fraud section documentation that was sent to me to notify that my information was breached. And according to this document, defendants Marlin Moore and Lashanda Moore were the ones who had access to these accounts, according to this documentation.
Any objections to this, Miss Alford?
No, no objections. I do have questions, but no.
Fair. All right, keep going, Mr. Adams.
And my last exhibit is a cease and desist order, which they breached the contract of the cease and desist order, which they received back in 2023. They constantly bombarded me with calls. As you can see on the call log, they kept calling, kept calling, kept calling, kept calling. I asked them to stop, keep calling. And then they had one representative to come into my rental, and people were just banging and banging on the doors and told me to give them their money, and they walked away. I didn't receive any paperwork, didn't receive anything, but I felt like it was an intimidating practice that they were trying to use. And let's keep in mind that this company, this law firm switched from Cooling and Winter to Lord and McDaniel, and they would send me documentations without proper notification of where it came from. So that's what I have here as my cease and desist.
Okay.
That's how long it.
All right, anything else?
That will be all, Your Honor.
Is there anything else you want me to know or that you want to tell me? That maybe you don't have documents, but you just want me to know?
The only thing that I have is just my condition of the explosion, that I'm not able to do much as I used to simply because of it. And so for a couple of years, I have not been able to do anything financial or anything in the sort other than have somebody to close my accounts just to make sure no situation like this continues to happen to me. And at this moment in my life, it is very difficult. I had to close everything simply because somebody stole all my information. So I'm sitting here like a duck, not having a business accounts, not having personal accounts, not having any accounts to my name because of all of this. This has put me in a big, big bond. And now I'm being sued for something that I did not even do, which causes more of an effect or issue on my psyche. So, Your Honor, the plaintiff did not prove that I opened these accounts. She just said that there's documentations, but the evidence shows that my identification were stolen and there's no documentation proving that I opened these accounts. Because of that, Your Honor, the plaintiff has not met the burden of proof, and I respectfully request that the judgment be entered in favor of me, the defendant.
What are you asking for today?
I am
Just a dismissal?
dismissal and full, never being opened again.
All right, and I just have a quick question for you.
Yes, ma'am.
And you can, I think we can stop sharing for the moment. Where were you living on March 30th of 2022?
I was either in or out of hospitals, or I stayed at a rental property on Brecken Circle.
Okay. And okay. And when did you move into that rental?
I think 2020, if my mom served me right.
And is that where you still stay?
Yes, ma'am.
Okay. All right, so you've been there all along. Okay. All right, so I'm going to turn it over to cross-examination. Ms. Alfred, I'm sure you have some questions. Go ahead. And yep, go ahead.
I just have like a few questions. I'm trying to pull up the document where it says like who was guilty of the fraud. I'm just looking for it.
What document are you referring to? The DOJ letter?
Yes, Judge. I'm looking for it in my
Ms. Hathorn, can
stuff
you
that
please
instructors
share that if you don't mind? Is that what you were talking about?
Yes, I just wanted a quick chance to just quickly skim and then ask about two questions if that's okay, Judge.
Of course.
Mr. Adams,
Yes,
do you
ma'am.
have anything showing that the fraud here in this case, or the identity theft in this case directly relates to the Capital One credit card agreement?
This is all I have.
Okay. And Ms. Hawthorne, if you can, would you be able to scroll up just a tad? I just want to see the date. And so was this, it says like this was sent in 2024. Was that when you filed the fraud claim? Or is that when?
There have been multiple conversations with this. This was the one that I saw during that time. I think there's an earlier date, so I can't confirm dates for you, but there is an earlier date than August 12th, 2024 that I received this notification.
I think she's asking you, when did you first file the fraud claim with the DOJ? Is that what you were asking, Ms. Alfred?
Yes, Judge, that's what I was asking.
Okay.
I cannot give you the exact date. I'm sorry, I can't answer that
Can
question
you give me
for
a
you.
year?
It had to either been
I mean,
2023 or 2024.
okay, but you don't have any documents for that today.
This is all that I have at the current moment.
Okay. Alrighty. And then Mr. Adams, you mentioned that your mail was stolen as well.
That's correct. I would come
So-
out sometimes and my mail is scattered all across the yard, or my items were just everywhere. Being mine, I'm incapacitated, so there's not much that I can do, only but look and see what's going on. I even noticed that my mailbox was even tampered with and destroyed and broken down. So I don't have anything else to tell you but that.
Okay, so yeah, so I was just wondering when the stealing of the identification happened, because I just want to get clarity. I know that you said originally, right, someone stole your wallet. Is that correct?
The documentations, that's what the documentation says, correct?
Okay, so they stole your wallet, and then just later on down the road, after the explosion and things like that, people were stealing your mail. Is that
That is
correct?
correct. That is correct.
Okay. And then this entire time you've been living at, my last question to you is, we have you on record for your address being 7005 Break-In Circuit, Lithonia? That's
That
correct?
is with me being in and out of the hospital.
Okay. And at any time did you receive any, statements from, do you remember receiving any statements from Capital One during the 2022-2023 years?
I received one documentation in mail from them, and I called them and let them notify them that it is a fraudulent account, and they should have that on record because it was recorded that it was a fraudulent account. So I don't know why I'm even being in court because of that.
Right. And what year was that?
I can't give you the date. I'm sorry.
Okay. But that was the only letter that you
That is
received.
the only letter, and I made sure that I gave a call. So I did do my
Thank
due
you.
diligence. Yes, ma'am.
Gotcha. Thank you. I don't have any further questions, Judge. Just
Okay. Mr. Adams, do you have any redirect? Is there anything else you want to add?
No, ma'am, I have nothing else.
Okay. All right. Any rebuttal, Ms. Alford?
no rebuttal, Judge, at this time.
All right. So we're going to move to closing arguments. I think you've both made your arguments very clear. So you can just summarize what the evidence shows and how you want me to rule. So Ms. Alford, I'll let you go first if you want, or you can reserve until after. It's up to you.
Judge, I don't mind going first.
Okay.
I can make it brief. Today we presented the business record affidavit, which has defendant's address and as well as credit card number and name on file with those business record affidavits. It shows that those transactions, right, and payments were made on that specific credit card. We've also done our due diligence of listening to the defendant, right, and taking his fraudulent claim serious. And so we did do a fraud investigation. We've provided the defendant with the validation of debt upon his request, upon his answer of fraud. And at this time, Your Honor, I believe that we present all that we can present to show that there was a credit card agreement. The credit card agreement was paid upon and used by defendant, and that defendant owes $5,978.53. And so at this time, Judge, we're just asking that the court rule in plaintiff's favor.
All right. Mr. Adams, closing statement?
In light of the above arguments and evidence, I respectfully request the following relief. The dismissal of the lawsuit. I ask the court to dismiss the lawsuit against me as the charges are a result of identity theft and not my actions. I ask for a correction of credit reports. I request the court to order the credit reporting agencies to correct my credit reports to accurately reflect the identity theft and remove the fraudulent charges. And protection from harassment. I seek an order to stop the collection company harassment and ensure compliance with the cease and desist order, while also if there's compensation that could be sought, I would like to receive that as well.
All right. So, all right, evidence is now closed. I'm going to issue my ruling. So as to your request for correction of credit report, protection from harassment and compliance, and compensation. So this is not a court of equity. The magistrate court is not a court of equity. So I really, other than paying money or not paying money, I do not have the authority to order a plaintiff to do anything like that. In terms of compensation, I don't think that you've met your burden of proof for any statute that would allow me to grant you compensation. You know, if you're going to raise counterclaims, you bear the burden of proof to show by a preponderance of evidence that you're entitled to that. And so I haven't heard enough evidence for me to be willing to grant that. As for the underlying case, I do find by a preponderance of the evidence, you know, where I'm stuck, most of these credit card cases, the evidence that's presented is exactly the evidence that Miss Alford presented. They're very pro forma. They give you credit card statements that show that payment was made. And that is, according to the terms and conditions on the credit card, a valid contract. Where I'm at, so normally so then the burden would turn to you, defendant, Mr. Adams, to raise questions about whether or not it really was you. Because, you know, we all know that just from living in the world, that somebody could grab a credit card, they advertisement out of your box and apply for the card. And people do that. Or, use your name and social security number. The thing that I think that I'm having trouble overcoming for your defenses is that most of the time when there's credit card fraud, people aren't making payments on the cards. And in this case, I think the plaintiff did prove by a preponderance of the evidence that they mailed you statements to the address where you were living at the time, where you continue to reside. And so therefore, I do think that I do find that the plaintiff met their burden of proof by preponderance of the evidence. And so I'm going to enter a judgment in the plaintiff's, in favor of the plaintiff in the amount of $5,978.53 plus court costs. Mr. Adams, my order, which you will receive via email, will have instructions and information about how to file a petition for review. You have the right to file a petition for review into either the state or superior court. That is what we now call an appeal, okay? And so there will be language in there. I believe you have 30 days from the date my judgment is entered, which is probably going to be today, or maybe tomorrow or Friday at the latest, to file your a petition for review if you disagree with my ruling, okay? And you have every right to do that. All right, I do appreciate very much the professionalism of both sides today. I think you both presented strong arguments and advocated well. So thank you for your time. You may be excused.
Thank you, Judge.
All right, and we are going to do a reset on position 1. Mr. Adams, do you prefer to do it in person or you prefer to do it online? Because I think you did a good job it worked fine with the documents. So if you prefer in person, I'm happy to do that. Otherwise, I think virtual probably makes sense.
Your Honor, I do whatever you request for me to do.
Well, no, I'm asking you. I mean, if you have mobility challenges, if it's easier for you to be on the computer, or if you think you might have a better chance in person, I mean, I'll defer to you. It doesn't matter to me.
The computer is fine.
Okay, so let's do it virtual then. Let me look at my dates. All right, so it will be the 9th at 1 p.m. In CT2. Again, thank you to both of you.
Can I ask a question before we dismiss?
You may, but I'm not going to argue with you about my decision, but you can definitely ask a question.
Never mind then.
Okay. All right. Thank you both for your time. I wish you all the best of luck. This concludes the business of the court today, and court is now adjourned for the 9 a.m. session. We will resume court at 1 p.m.